Hi, everybody. This is Jennifer Braceras with Independent Women's Forum, Center for Law and Liberty. And today we're talking about due process denied, the Department of Education's enforcement of Title IX on campus. Joining me to talk about that topic today are Cynthia Garrett, co-president of Families Advocating for Campus Equality, Dr. Mukund Vengalattore, a physicist and former professor at Cornell University, and Caleb Kruckenberg, an attorney with the New Civil Liberties Alliance. Thank you all for participating in this discussion.
Thanks for having us.
Thank you.
It's an important topic, and there's been a lot in the news about it lately. We've heard a lot about these so-called kangaroo courts on campuses, and essentially college campuses denying due process to both students and faculty members who are accused of wrongdoing. But Cynthia, I'd like to start with you because you represent an organization founded by parents of students who were unjustly accused of sexual misconduct on campus. And I'm wondering if you could give us some background about the climate on college campuses today when it comes to issues of sexual misconduct, and perhaps tell us a little bit about why you started your organization.
Well, I didn't start F.A.C.E, but I came in very early in 2014. I was on the first board of directors, but it was started because there was obviously a need. We started to realize that more and more students were being unfairly expelled or suspended from their schools based on sometimes evidence that contradicted the accusation. So the idea was to offer support, and emotional support is incredibly important for our organization because of the 1,500 plus students that we have. Probably most of them have considered suicide. And the other aspect is that we really felt we needed to get out there and advocate for these students, since most of them can't advocate for themselves. You know, if anybody comes out and says that they've been accused, obviously, and the immediate thought is, well, look what they did, they raped somebody. So that was how we started. The problem really is kind of an old problem. It started with the third wave of feminism, the radical feminist belief that America's a patriarchy and men really just desire to subjugate women through sex. Slowly, it's permeated the campuses, perhaps because of the left-leaning population on campus. And back, I think it was 20, 30 years ago, Antioch College tried to enact an affirmative consent policy, and at that time, everyone laughed. There was even a—
Right, yeah, it was a Saturday Night Live skit, wasn't it?
Two lawyers, one on each side, taking notes. Well, is it okay if I touch your breast? Yeah, I mean, really, it seemed absurd, and it still seems absurd to me. And in fact, I think it isn't workable, and there's a lot of problems because of it. But as a result, this group of ideologues got the attention of the Obama administration, who I believe never consulted with other perspectives, and came out with the Dear Colleague letter, which of course Caleb is going to discuss later. But generally, the feeling was schools weren't responding to sexual assault on their campuses, and there is some truth to that. They were pushing it under the rug. I mean, I have two daughters. I understand that it's important that schools not allow this to happen, or not ignore it if it does. But as a result, the Obama administration, through its Department of Education, came down very hard on schools, threatening them with loss of funding, which, as it turned out, they couldn't do, but the threat was still there, and coercing them. They were really coercing them into following what they felt were the right methods to use in adjudicating these cases. But generally, they basically lowered the standard of evidence so that, it's more likely than not. They broadened the definitions to basically any unwanted touching. And they actually said that the due process for the accused student should not be allowed to interfere with victims' rights. So all of those things came together. At the same time, of course, they were listing colleges on what I call the list of shame every time they opened an investigation, and put them through horrible, horrible investigations that lasted years and made them go back years as far as their adjudications. But what happened then was schools started to slant the process to be able to find students responsible, did things like wouldn't tell them what they're accused of before they interrogated them, really. They wouldn't let them see evidence. I mean, it's shocking, some of the things. Can't see witness statements, can't see the investigation report on which the decision makers rely.
And let me just interrupt you 1 second, because I think one thing that's really important to emphasize is that when colleges investigate what they call sexual misconduct, that is an extremely broad term. So that could be anything from a forcible rape to a sexist joke that someone's found offensive, or in the case of at least one professor that I've heard of, they brought a professor up on charges for offhand remarks he made over the course of several decades. You know, a comment in the 1970s, another one in the 80s, another in the 90s, and they strung it together to kind of weave together an impression that this person, you know, was a sexual harasser, when at most maybe he just made, you know, a few jokes that people years later decided they were offended by. So the term sexual misconduct, one of the problems with it is that when you hear it, most people think the worst, right? They think that there was some sort of forcible rape, when in fact it could have been any type of conduct whatsoever. But I'd like to bring Caleb in here to talk a little bit about the law, and because in ordinary cases of student misconduct or even faculty misconduct, there would be an investigation by the university. That's normal. And presumably universities were conducting investigations of all sorts of things, not just allegations of sexual misconduct, prior to the Obama administration sending out what's known as the Dear Colleague letter. So tell us what the Dear Colleague letter said and what changed after that went out.
So probably the easiest way to think about it is, you know, when we talk about Title IX, which is something that we're talking about today, Title IX is a very simple federal statute. It says colleges, universities can't discriminate on the basis of sex. That's it. And how colleges and universities go about making sure that they don't discriminate, you know, they have a lot of latitude. And for years, colleges took the decision that they said when people are accused of sexual misconduct, as broadly or as narrowly as they'll define it, they set up campus disciplinary systems. And in a lot of universities, like Cornell, for example, which that's one that, you know, we care about because of Dr. Vengalattore, Cornell set up a system where if you were accused of misconduct, you were allowed to see the evidence against you. A prosecutor essentially had to prove your guilt with clear and convincing evidence, and you were entitled to a live hearing where if someone made an accusation, they had to appear, and you were allowed to question them to make sure that they were telling the truth. In the Obama administration in 2011, the Department of Education decided, and really just the Office of Civil Rights within the department decided, we want to change the rules, and what colleges have been doing, the protections they've been giving are not acceptable. And they claimed the authority under Title IX, which is sort of, you know, ridiculous when you think about what Title IX actually says.
Right.
And they told colleges, no, you have to adopt a preponderance of the evidence standard, which, as Cynthia said, is just more likely than not. They discouraged colleges from allowing a live hearing. They discouraged them from showing evidence to the accused. They said, in no uncertain terms, that cross-examination of alleged victims was something that should be avoided and was inappropriate. And after that happened, suddenly colleges started changing their processes. And I think
the notion was, I guess, right, from the Department of Education, was that accusers felt that they hadn't gotten justice before, or what was the impetus behind saying that colleges needed to adopt these procedures? What was fueling that?
Well, I think it was this sense that colleges somehow had not been finding enough people responsible, or not having a strong enough reaction to misconduct on campus. And
right. So they would look, the Department of Education would look at the statistics of findings of responsibility. I won't say findings of guilt because it's not a criminal situation, but they would look at statistics on findings of responsibility, and if they didn't see that a college had enough quote unquote convictions or findings of guilt, they would view that as evidence, not that there weren't problems on campus, but as evidence that college wasn't doing enough, because the presumption, of course, was that sexual misconduct was rampant. Is that right?
Exactly right. And so this really, I think, was an effort by the administration to try to make the numbers go higher. We needed to find more people responsible. And it's certainly a lot easier to do that by taking away procedural rights and making it easier to find people responsible.
And I think the presumption is also has a lot to do with what Cynthia said before about sort of this feminist notion of rape, that and you know, there are a lot of feminist notions that, well, you know, accusers that if you're questioning accusers, you're re-victimizing them. That's one mantra you hear over and over again. And so I think that the administration and ultimately the colleges bought into this theory, and therefore felt that they couldn't allow people who were accused to face their accusers and question their stories.
Right. And another thing that we see a lot is this victim-centered training for the investigators. This is something that came up a lot, and that's been really promoted by the Office of Civil Rights, is this idea that the investigators are really not allowed to question an accuser's story very, very, you know, they can't question it very toughly, because there's this idea that someone who has been victimized shouldn't be able to give a coherent story or give a consistent story, and really that's a sign of trauma. And the idea, you know, that's very paternalistic, first of all, for someone who has actually been the victim of misconduct, but it also presumes that this person actually suffered some sort of misconduct, that something happened. And I think in a lot of cases that's not true.
It's also very Orwellian in the sense that, you know, if they are willing to talk freely about it, then we have to believe them, and that's evidence that there was a crime. But if they're not willing to come forward and talk about it, well, that's evidence of trauma, so therefore we still have to believe them. I mean, there's no way to prove your innocence, essentially. But I'd like to bring in your client, Dr. Vengalattore, now to talk about his experience. You were a professor, doctor, at Cornell University in the physics department. And I'm wondering if you could just tell us your story. What happened and how were you treated by Cornell University when there was an accusation against you?
Sure. So maybe if I can just start out with some background. I came to Cornell in 2009, and I was a professor in the physics department, and I established some atomic physics with a few graduate students and a few undergraduate students. And one of the students, the student who would go on later to make these accusations, was having a lot of problems getting her experiments to work or working alongside the other members of the team and so on. So long story short, about 2-3 years later in 2012, we agreed, or we decided, that the situation had become untenable and that it would be best for everybody that if she left the group and found another research team. At the time, I didn't know about it, but after she left my team, she had apparently bragged to her colleagues that I would have a very hard time getting tenure if she had her way. I did not know of this at the time, but a couple of years later, in 2014, I came up for my tenure review, which is a long process where the department and the university evaluate my teaching and my mentoring and my research accomplishments and so on. And at the time, the student submitted a very hostile and negative letter as part of that tenure process, and had also tried to coordinate negative letters with other students as well.
Now, my understanding is that her letter in opposition to your tenure said nothing about sexual misconduct whatsoever.
Absolutely nothing. And the department was made aware of her kind of vendetta to me, kind of sabotage or manipulate the tenure process. But despite the effects of that negative letter, the department actually recommended my tenure in September 2014. And already at that point, I mean, this gets back to your point about the broad definition of sexual misconduct. She had even leveled complaints, that I had omitted her middle initial in the author list of a publication, and apparently the omission of the middle initial counted as sexual harassment.
Right. She said that you
Even
forgot to put her middle initial in a paper, and that she was offended by that.
That the absence of the middle initial in your name was sexual harassment.
You can't make this stuff up. Okay. All right. So then what happened?
So the department even then had, the physics department, my colleagues in the physics department even then had said that her conduct in trying to sabotage the tenure process would warrant a letter of censure in her file or even expulsion from the PhD program. What I didn't know at the time and what we now know is that immediately after the department had recommended my tenure in September 2014, the chairperson of the department called up the student and told her that I was about to be tenured. And 2 days after that, she contacted faculty members and administrators at Cornell and told them that she was the victim of a sexual assault sometime in 2010.
So just to get this straight, she left your lab
in 2012.
And then when you were up for tenure, she made allegations against you that didn't include any sexual misconduct other than misspelling her name or something on a paper, leaving an initial out. And she never said anything further until she found out that you were going to get tenure, at which point she came forward with new allegations altogether that were more serious in nature.
And which had apparently allegedly occurred 4 years prior, so in 2010.
So 4 years after the alleged incident. Okay. And so what happened when the department received those allegations?
I was not told about it. There was no investigation whatsoever. And my first inclination or my first intimation that there was something amiss was that a month later, barely a month later, after the department had recommended my tenure, the dean of the college overruled the department and denied my tenure. And I remember my colleagues just being stunned at what happened because it is highly unprecedented for a dean to overturn the department's recommendation. And they said that there had already been several flaws in the tenure process, and that I should appeal the dean's decision, and submit evidence that the dean was mischaracterizing my group, and that the dean's claims or justifications for her denial of tenure were not valid. And of course, the dean never even mentioned what the allegations were in her justification. She just made obscure references to charges of misconduct, except I was not told what these charges were, and there never had been any investigation.
Now, so were these allegations at this point being investigated in a Title IX disciplinary tribunal, or were they only being investigated in the tenure process?
They were, as far as I can tell, and based on the documents we have, there was absolutely no investigation whatsoever.
Okay, so it just came up as part of the tenure review process.
Yeah, right. Go ahead.
And eventually, this changed from the tenure review to they did open some sort of Title IX investigation. And that was really the first time that he knew, really the first time he heard about the accusation was during the initial interview with the Title IX officers.
And that
halfway through.
That happened almost 6 months after she had leveled the investigation and after the dean had already overruled the department and denied my tenure.
So then once the Title IX investigation was opened, what happened at that point? Because my understanding is that in earlier times, Cornell would have allowed you, the accused, to have an advisor, to know about the charges that were brought against you, specifically what the allegations were, to question the accuser. And actually, I believe that the Cornell had a statute of limitations previously that prevented people from coming forward 4 years after the fact with allegations. But I may have my facts wrong on that. But
no, you are absolutely correct. And so the way the investigation opened was that I got this email basically summoning me to the Title IX or the what's known as the WPLR office. And the email said that the investigators had been authorized by the very same dean to conduct an investigation into what they called an inappropriate relationship. They would not provide any details. So when I actually went to the office, they said that there had been an allegation. They refused to answer my questions about when the allegation was made or what the details or what the time period of this inappropriate relationship was. They refused to answer any such questions. And almost as an afterthought, they said, by the way, the student claims that the way this inappropriate relationship started was that you did sometime in 2010, you apparently did not come to the lab for 1 day or many days or whichever version of the allegation you believe. And because you did not come to the lab, she came to your house to check on you. And she claims that when she came to your house to check on you, you assaulted her.
And that was the first you had heard of this?
Exactly. That was my first inclination that this was not a relationship, but a sexual assault investigation.
Right. So that must have been very shocking for you to hear. Did you?
And so when I asked them when this was supposed to have happened, they quite literally gave me a calendar of 2010, 2011, and asked me to circle all the days within a 3-month period that I was actually in it. That was their answer.
So you're hearing for the first time that you're being accused of sexual assault. The accuser never went to the police. Did you feel the need to, at that point, immediately get a lawyer?
That was quite literally my next question was, why is the university investigating this? Because there should be a criminal matter investigated by the police. And also, don't I need a lawyer for this? And they said, no, we are just trying to ask questions here. A lawyer is not necessary.
And so at what point did you obtain counsel?
That happened much, much later. So the investigation, which started in February of 2015, went on throughout the summer and past the summer. And throughout that process, they would not give me any details of what the allegation was. They would not show me any evidence of what they claimed was supported her allegation. They asked me to list all the students who were working in my group at the time. I did so. But I later found out that most of the students were not interviewed. I repeatedly asked, it was a struggle even for me to even get the witness testimonies. And when I finally got my hands on those witness testimonies, I found that they had been heavily redacted. The witnesses, most of the students in my group who were actually present at the time and could provide first-hand information about my interactions or the dynamics of my group were never even interviewed. And the few that were not asked any questions about the allegation. The witnesses suggested by the complainant openly admitted that they did not live in Ithaca, and most of them had never even met me. And that a few days or a week before they were contacted by the investigators, this student had actually contacted them and told them what the allegation was. And they openly admitted that they were very surprised to hear this allegation.
So, Caleb, maybe you could tell us a little bit about what the university did with this information and why you believe it resulted in a denial of your client's due process.
Well, so the investigators that called Dr. Vengalattore into the office were the ones who ultimately made the decision. And they were working very closely with this student who had made this allegation. And they really worked directly with the student and with an advisor that they appointed for the student. And the investigators and the student and the advisor all sort of got together and they came up with a story that they could try to fit into the facts as they found them. And, you know, they interviewed witnesses, and when the witness stories didn't really line up, they disregarded the witness stories. They refused to interview witnesses who I think would have provided exculpatory information. And, you know, there was no adversarial process. It was really the investigators were acting as the prosecutors. And then ultimately they came up with a report with no hearing, with no chance for Dr. Vengalattore to challenge the accusations or contest it or prove his innocence. They came up with a report saying that he was responsible. And
so they were essentially judge, jury, and executioner all in one. Absolutely.
I mean, it's sort of like if the police officers were every line of the system, and you know that is it doesn't pass the laugh test,
right?
But unfortunately, you know, these are very serious allegations, and these have very profound consequences because,
right?
You know, these investigators found Dr. Vengalattore responsible, and now they're spreading that around, and they're saying we made this finding after a hearing or after an investigation.
Right. So unfortunately, this isn't uncommon, right? And Dr. Vengalattore's story is one of many, many stories. And I want to bring Cynthia back in here to talk about the pattern that we're seeing across the country at all sorts of institutions. And you know, tell us a little bit about that.
This is so not unusual. I mean, thousands of students have gone through this. It's really shocking that if these schools wanted to know the truth, that they would hide the evidence the way they do, that they would deny these kids the right to see it, or at least, you know, stick them in a room and tell them they can't take notes when they review it. There have been courts that have been shocked by the disparity in abilities because they turn students' attorneys into what we call potted plants.
Mm-hmm.
They'll have their own general counsel or a Title IX officer who's a lawyer present their case. They basically tie their hands behind their back in trying to defend themselves. And these kids, it is the most shocking process I've ever seen. My reaction was, you can't do that. This is America. But apparently they can do it. And then they use all these crazy, like Caleb mentioned, trauma-informed theories to say anything that a victim does or a complainant does that's inconsistent with having been assaulted, or inconsistent statements or even lies. You know, like you said, that's evidence of trauma. Not only
either way, it's evidence.
Right.
The evidence is ignored because, oh God, that's typical counterintuitive victim behavior. I mean, it's a real problem. And some of these, we have kids, you know, the complaints are brought 2 years later, no witnesses, no evidence around. It's just, and they ignore it.
What I have found in researching this, one of the most shocking aspects of these policies to me, and then not all universities have this, but many universities prohibit the accused from discussing the charges against them with friends or colleagues, which is very traumatizing because they can't go and get help or look for witnesses in their own defense. That is very, in my view, Star Chamber-like, worse than the Star Chamber, actually. I mean, you are being told that you're being accused of something, and if you tell your roommate or your colleague or your parents or an attorney, you're going to be sanctioned for doing that.
Right. That's gag orders.
Exactly.
But the Department of Education's Office for Civil Rights, in its proposed regs, precludes gag orders. So hopefully that'll remain when the final regulations come out. But not only do they deny you the opportunity to discuss with your witnesses, they won't tell you sometimes the identity of the witnesses or let you read their statements. It's just, no wonder these kids are so traumatized after this experience, so frustrated. I can't tell you how horrible it is. And the other thing I wanted to mention, like Dr. Vengalattore mentioned, is they often make these accusations when they see the accused having success or graduating, and they're angry. Look at Patrick Witt, who was at Yale and Harvard Law. He got accused. He lost an NFL career, a job offer, and a Rhodes Scholarship, and nothing ever came of the allegations.
Well, yeah, and there's the case at Yale University of Jack Montague, who was the captain of the basketball team, and he had an allegation made against him by a woman he had been dating and broken up with. And she didn't even come forward with the allegation. The administrators at Yale heard that there was a young woman who, quote unquote, had a bad experience with Montague, and they brought the allegations and essentially suspended him and kicked him out of school right before Yale was about to go to the NCAA tournament for the first time in 4 decades.
The Rose Bowl, I think it was. Horrible.
Yeah.
That also happened at USC with, I can't remember, Zoe Katz and Matt Bormeister. She never made a complaint. She said she wasn't a victim, but they didn't listen, and they expelled her. I think Neil in Colorado was the same. I mean, how arrogant of these school administrators to think they know that someone is a victim and that person is just not able to admit their victimhood.
Right, exactly. Well, so by my count, there have been at least 500 lawsuits brought against universities by students who claim that they were denied due process and had their rights violated by the universities. And, although there haven't been many that have gone to trial and been completely successful, the universities are settling these cases out of court because it's becoming embarrassing to them when it's revealed how they mistreat people and don't even give them a basic chance to prove their innocence. But I do want to talk quickly before we go about the Department of Education and what they're doing, because when Secretary DeVos came in, she did withdraw the Obama-era guidance that had encouraged is a nice word, I guess, encouraged schools to adopt these draconian procedures. And the Department of Education in this administration has issued new regulations that attempt to protect the due process rights of both the accuser and the accused. But Caleb, your lawsuit on behalf of Dr. Vengalattore is suing the Department of Education, and you're saying that's not enough. Why?
Well, probably the simplest reason why it's not enough is that the department is still enforcing a number of consent decrees that they entered into with universities.
Okay.
And sort of the backstory there is that the Office of Civil Rights tried to enforce the Dear Colleague letter, and they threatened to sue a bunch of universities if they didn't take away procedural protections. And they entered into agreements, and those are still on the books, and those are still being enforced by the Department of Education. And so we're very happy that the department has at least acknowledged some of what they've done. But at the same time, they're still enforcing these changes. And even though the department has proposed certain regulations that might improve the status quo, when we compare the proposed improvements with a robust, meaningful system like the one that a lot of universities used to have, it doesn't go anywhere nearly far enough. I mean, there's still, even in the proposed regulations, there's a presumption against cross-examination, and there's a very low burden of proof. And certainly from our perspective, we'd like to see if you're going to make these kinds of accusations, then you have to give people procedural protections, because the last thing we want is someone to be found responsible when they didn't do anything wrong. I mean, these kinds of accusations are very serious.
So what would you like to, what is the goal of your lawsuit? What are you seeking? What remedies are you seeking?
Well, part of what we're seeking, obviously we filed a lawsuit against Cornell University for the way they conducted this investigation. But one of the remedies we'd like to see is an order from the court saying that the Department of Education has no business regulating campus discipline at all. And I think that's kind of where I started this discussion. If we're talking about Title IX, which is where they claim their authority, Title IX doesn't say the Department of Education should be micromanaging a college and telling it how it has to conduct an investigation.
Mm-hmm.
Title IX just says colleges can't discriminate on the basis of sex.
Right.
And what we're hoping to accomplish with this is an order saying a college can't, or the Office of Civil Rights can't make college have a specific process. If the college decides a fair process is right for the college, that should be acceptable, and the Department of Education shouldn't get involved.
So I mean, I actually agree with you that, you know, what's the constitutional basis for having the executive branch micromanage the disciplinary proceedings of thousands and thousands of colleges? I mean, that seems like an unbelievable long arm of the government reaching out and you know, telling many private institutions what to do as well as public ones. But I worry that even were you to succeed and the Department of Education to get out of the business of micromanaging college discipline altogether, there are quite a few colleges that would keep these procedures because, you know, these campuses, as we started off saying at the beginning, these campuses have bought the dogma. They've bought into the dogma that there is a campus rape crisis and that, you know, they need to do something about it. So,
and then that's where we look to the courts. I mean, my organization, the New Civil Liberties Alliance, you know, we're founded to go to court and fight about these issues. I mean, you mentioned the 400 plus student lawsuits. Those have been very successful, and there are a number of very important court decisions saying, doesn't matter why you did it. It doesn't matter that the Department of Education made you. You cannot deny people due process in these kinds of investigations. And, you know, I'd like to be able to have a more systemic win, but if we have to, we'll go to court and we'll represent individuals.
And where can, if a student feels that he or she has been falsely accused, where can they go for help? I presume, to begin with, to Cynthia's organization.
Right. They go to F.A.C.E campusequality.com, and there's a contact form where they can fill out their name and they'll be contacted. We vet people very carefully because we facilitate their ability to speak to each other. And that's hugely reparative to understand and know somebody else is out there that's gone through what you've gone through. I do want to add about what you just discussed about the conduct codes. Schools will have conduct codes whether the Department of Education is involved or not. And like you said, Jennifer, the schools have expressly said they aren't going to change. And that's because of the ideology and the pressure from their students and faculty as well. Schools, you know, we need to fix what's happened. It's not just going to disappear. Did we lose Jennifer?
I think we did.
What's that?
Well, there she is.
Yeah, I'm sorry, I disappeared.
Part of the problem that Caleb brought up with OCR not responding, it's in the regional offices because the regional offices are still staffed with civil service leftovers who don't want to follow what Betsy DeVos wants them to do.
Right, right. Well, it's going to be a long haul, but I wish you the best of luck with your case, Dr. Vengalattore, and If people want to learn more about this issue, they can go to iwf.org and look at our work on Title IX. They can go to the F.A.C.E website, or they can go to the, I think it's ncla.legal. Is that right, Caleb?
It's NCLA legal.org.
Okay, sorry about that.
That's right.
And I hope people will educate themselves about what's going on our college campuses today, because it's not pretty.
Yeah.
Thank you very much. Appreciate you all talking to me today.
Thanks for giving us the opportunity.
No problem. Bye-bye.
Bye.